All right, the judge in this trial, Judge Deborah Nelson, has just denied the state's motion to sanction John Donnelly, the Vietnam War of combat medic who testified earlier on behalf of the defense, saying it was, in fact, the voice of George Zimmerman on that 911 call crying out for help. Judge Deborah Nelson saying that for all practical purposes, there was no violation, not enough to make his testimony go away. Sonny Hostin, Mark Nijame, let's get your quick analysis on what this means. Are you surprised, Mark, by her decision, or you think you anticipated that she would allow John Donnelly's testimony to stand?
Well, the state was asking for the most severe sanction, and that is a complete elimination of the testimony. The courts are loath to do that. But I did think that it was possible that she would have said something to the jury to say that, in fact, he was there, and then that could have been a sanction that was less than the complete exclusion of the testimony. So I thought that might be a possibility. So I think it could have gone either way, and it's not an unfair ruling. Remember, to exclude testimony completely could be a strong appellate issue if, in fact, there's a conviction in this case. So I think she took the safe route.
Yeah, and I think it's pretty apparent,
and the appropriate one.
Sonny, it's pretty apparent that that testimony from John Donnelly was pretty effective, pretty powerful testimony. He got very emotional. He had heard men crying out for help in a time of warfare in Vietnam, a combat medic, if you will. And as a result, he said he had no doubt that was the voice of George Zimmerman crying out for help. And that testimony, the judge has now ruled, will stand.
Yeah, it was very important testimony for the defense, no question about it. That, I think, is one of the reasons why the state argued so vigorously in terms of sanctions. They wanted it completely stricken from the record. I agree with Mark, though. I thought perhaps that she would split the baby here. I thought perhaps she would give some sort of curative instruction to the jury and explain to the jury that he had, in fact, been in the courtroom and had the opportunity to listen to witness testimony, other witnesses testify. I don't know that that would have been a huge appellate issue, and I think that would have been more appropriate than doing nothing, because it really is significant that he was in the courtroom during parts of witness testimony and seemed to have changed his testimony from what he said at deposition to what he said on the witness stand. So I'm surprised that the judge is refusing to do anything.
You know, let me just listen in quickly to see what the next order of business is she wants to do.
Some suggested changes to some of the substantive ones. The court wanted to go through just the general instructions at this time to see if we can at least have an agreement as to those. First one, although it's not membered, it's just thanking the jury for their attention during the trial and paying attention to the instructions I'm about to give. Is there any objections from the state to this instruction?
No, Your Honor.
From the defense? Okay. And Mr. Zimmerman, you don't have to stand up. Do you have a copy of these instructions that you can look at them with us?
Yes, Your Honor.
Okay, if you'll please do so, I appreciate it. Yes. Okay. The very first page is just the style of the case. The second page is what I just read.
I'm sorry, were you addressing?
No, you may be seated.
No objection. Is that what you're asking?
Yeah, I wanted to make sure Mr. Zimmerman had a copy in front of him.
He does, and he's reviewing with us, Your Honor.
All right. Then the second page is the statement of the charge. Any objection from the state?
No, Your Honor.
From the defense?
No, Your Honor.
Neither one of you have to stand while we go through these. We'll reserve as to the homicide instruction because it's substantive. And any suggested changes by either side, if you could give them to the other side tonight via email so we can discuss them tomorrow. The same would be second-degree murder instruction. The next, we'll reserve that until the morning. The next one is possession of a firearm and discharge causing death. Is there any objections to this by the state?
No, Your Honor.
By the defense?
Substantively, no, Your Honor. I believe that it's appropriate based upon the charge. We might readdress that when we go over second degree, but I think it's accurate.
Okay. The next one is when there are lesser included crimes or attempts, and what the state has listed in the proposed instruction is manslaughter and aggravated assault. Is the state requesting these lessers?
Yes, Your Honor.
Any objections from the defense?
We object, Your Honor, and I think that would be something to take up tomorrow.
All right. Manslaughter is a substantive one, we'll bring up tomorrow. Aggravated assault is a substantive one. Possession of a firearm and discharge causing death, is that a... Is that the same as the one that,
Because I don't see it in mine the second time, Your Honor. I thought we just addressed that one.
It is, as it relates to the aggravated assault, lesser is where it is.
but it's the same
It is.
instruction, and when the instructions are read, would there be any objection to not reading it a second time? Okay.
I think as long as there's a reference made and we can sort of, if the aggravated assault lesser is given, as long as there's a reference made to the use of a firearm before, because that's the 1020 life enhancement, and there are separate ones for aggravated assault than there are for second-degree murder.
Right. The next instruction is the justifiable use of deadly force, and that's going to be subject to discussion tomorrow. And please, both sides take into consideration the changes that are currently before the Supreme Court on that instruction, so we need to have some agreement as to how that's going to be presented to the jury. Plea of not guilty, reasonable doubt, and burden of proof. Any objection from the state?
No, Your Honor.
From the defense?
No, Your Honor.
Date of crime, any objection from the state?
No, Your Honor.
From the defense?
No, Your Honor.
Venue, any objection from the state?
No, Your Honor.
From the defense?
No, Your Honor.
Weighing the evidence, there's 1 through 5 are always given, and then we have 6 through 10. Is the state requesting any of the 6 through 10?
I believe certainly 8 should apply, and I believe that is the only one the state would be requesting.
Is the defense requesting any others of 6 through 10?
None of those, Your Honor. I'd like to have a presentation by the state on the inconsistent testimony.
Well, both sides have tried to impeach by deposition testimony or other testimony of the certain witnesses, so I do think that that does apply.
Fair enough.
Are there any 6, 7, 9, or 10 neither side is requesting?
No, Your Honor.
Can you please prepare a new instruction that has 1 through 5 and then number 8 as number 6?
Yes, Your Honor.
Thank you. Expert witnesses, any objection from the state?
No, Your Honor.
From the defense?
No, Your Honor.
Defendant testifying will not be given, so defendant not testifying, any objections from the state?
No, Your Honor.
From the defense?
No, Your Honor.
Defendant's statements, any objection from the state?
No, Your Honor.
From the defense?
No, Your Honor.
Rules for deliberation, any objections from the state?
No, Your Honor.
From the defense?
Other than I don't know what we want to do with possibly 7. I don't think there were any questions written that were not asked by the court. A couple of the jurors asked some oral questions more along the lines of could a witness speak up or that sort of thing, so I don't think 7 needs to be there.
Is there defense agree with that?
We do, Your Honor.
So number 7 will not be given if I can have an instruction that takes out number 7.
Yes, Your Honor.
The next instruction is regarding notes. Any objection from the state?
No, Your Honor.
From the defense?
No, Your Honor.
Judge Deborah Nelson going through the formal charges that will be read out, the instructions that will be read out, I should say, to the jury tomorrow morning as they begin the closing arguments. One significant difference between the state and the defense over whether or not a lesser charge or charges might be allowed to be considered by the jury. Manslaughter, for example, as opposed to second-degree murder. You heard the defense. You heard Mark O'Mara saying they will resist that. Sonny, let's get you and Mark to quickly weigh in on this. How big of a fight is this going to be? Because it's clearly a lot easier to convict someone of manslaughter, if you will, as opposed to second-degree murder.
I think that's right. I mean, these are lesser included offenses that are generally asked for, and judges generally, if there is evidence to support giving the instructions to the jury, the judge gives the instructions to the jury. And so I suspect I'm going to defer to the Florida lawyer that practices here in Florida. But what is surprising to me is not only did the prosecution ask for manslaughter, they also asked for aggravated assault, which is something I don't think we've talked about before. So now the jury, if the judge so instructs them, now they have sort of a cornucopia of possibilities in front of them. They've got murder too, they've got manslaughter, they got ag assault. I mean, that's pretty good for the prosecution.
If they get that, they're going to resist that, the defense, very quickly, Mark.
Yeah, Sonny is correct. And these are Category 1 lessers are going to be included. This defense is going to make a record, but they're going to get in. The interesting thing is an ag assault, as you heard there, has mandatory minimums applied to it, whereas manslaughter doesn't. So they could end up going to the lowest, aggravated assault with a firearm, and that's subject, because it's a enumerated offense, to a 10-20 life, whereas if they get manslaughter, it's not necessarily a mandatory minimum sentence. So it's not a mandatory minimum sentence. So it's really interesting, and the jury will never know this when they get told this.
Yeah, the jury.
So in other words, he could, if he's convicted of a lesser, he could even get more time.
Yeah, they might think that they're doing a favor by coming up with a compromised verdict, and it could end up being more time. So it's an interesting place. So the defense is going to fight this real hard, but I think it will be a fight ultimately to no avail, but they still need to make the argument.
All right, guys, hold on for a moment. We're going to continue to monitor what's happening in the courtroom. Also, the former Sanford, Florida police chief is now, for the first time, speaking out. He's telling CNN why he resisted pressure to arrest George Zimmerman. Stay with us.